So very good morning, all the participants. Today we'll start from section number 1. We just had an overview of the IBC yesterday morning session, and now we'll start section by section. So the first section first. So if we read the preamble, what preamble says? So preamble says it is an act to consolidate and amend the laws. So there were earlier laws also, but now all the laws, SICA, RDB, SURFACE, and so many other laws, provincial insolvency, presidential insolvency, all those laws have been consolidated at one place and amendment is also there in the various laws, because suppose in the income tax act says that if there are dues of income tax, then they will be recovered as arrears of land revenue. But here in IBC, the government is at a lower priority. Government has kept itself at a lower priority because government is of the view that if the business survives, then everybody will gain, even the government will get the taxes. But if the business fails or if the business itself dies, then nothing will come to anybody. So thereby, that is the reason they have kept their own dues also at a lower priority in the liquidation mechanism. And government dues being operational creditors, naturally they are at a lower priority. But at least liquidation value is ensured to them either in resolution or liquidation. So this is the thing. So it is an act to consolidate and amend the laws relating to reorganization and insolvency resolution. So first is reorganization. A company may be converted into LLP. LLP may be converted into a company. Restructuring may be there. Amalgamation, merger, demerger, and insolvency resolution. So first of all, we have to try to resolve the insolvency of corporate persons, partnership firms, and individuals. So everybody is covered here. Whosoever is doing business is covered here in a time bound manner. So time is also of the essence, and we have already seen that 180 days, one time extension of 90 days, and maximum 330 days. For maximization of value of assets, another important aim is to maximize the value. There should be least destruction of value. There should be least diminution of value, and that is possible only when we do it in a speedy manner. To promote entrepreneurship, so new entrepreneurship will also be promoted because the new business entrepreneurs will enter the business which is into doldrums now. Availability of credit and balance the interest of all the stakeholders, including alteration in the order of priority of payment of government dues. So it aims at also balancing the interest of all the stakeholders. The balancing act is evident in section 30, which says that operational creditors should get at least the liquidation value. Similarly, the dissenting financial creditors who did not vote in favor of the resolution plan, they also get at least the liquidation value, including alteration in the order of priority of payment of government dues. So this is another aspect that the government itself has kept itself at a lower priority. And to establish an Insolvency and Bankruptcy Board of India. This is the regulator, IBBI is the regulator, and for matters connected therewith or incidental thereto. So the preamble, in a very short manner, it says the entire thing about IBC. So first of all, there has to be a resolution in each and every case. You cannot directly go to liquidation, even if there are financial issues. So first, section, short title, extended commencement. This code may be called the Insolvency and Bankruptcy Code 2016. Why it is called the code, not an act? Because it encompasses within itself not only sections but regulations, rules, everything. It extends to the whole of India. Now you must have noticed that there is an asterisk mark after this. It extends to the whole of India because earlier when IBC came in 2016, Part 3 was not applicable to J&K. But now, because of this abolition of Article 370, now this IBC extends to the whole of India. it shall come into force on such date as the central government may by notification in the official gazette appoint. Provided that different dates may be appointed for different provisions of this code, any reference in such provision to the commencement of this code shall be construed as a reference to the commencement of that provision. So it was introduced in phases. As of now also, there are certain sections for which the rules and regulations are not available, like say for individuals and partnership firms. So if an individual wants to avail the fresh start process, then there are no rules and regulations. Because if somebody wants to avail, there has to be a form, there has to be a procedure, but that procedure is not there. Simply sections are there. Similarly, for individuals and partnership firms also, rules and regulations have not been notified except in case of personal guarantors to corporate debtor. So still, as of now also, there are certain sections for which rules and regulations are not available. Now, section 2, application. Any question on section 1? The only question they could ask is whether part 3 is applicable to J and K. Now the answer is
Yes.
the whole of code is applicable to entire India. Because if sometimes you happen to see the old question papers. So in old question papers, they might say that, okay, part 3 is not applicable, but now the entire code is applicable to whole of India. Yes, section 2. Section 2 talks of application. The provisions of this code shall apply. Now, as we have already seen, there are 5 parts in IBC. They will sometime refer to the code and they will sometime refer to the part. So whenever they are referring to the code, it means it applies to the whole of the code. And when they are saying the provisions of this part, then that means that those provisions are applicable to that part only. So you have to very carefully read whether they are referring to the code or the part. So section 2 is applicable to the whole of the code. The provisions of this code shall apply to a company incorporated under the Companies Act or under any previous company law. So a company which is incorporated under the Companies Act or under any previous company law, it is applicable. Any other company governed by any special act for the timing in force, except insofar as there are 2 parts. Any other company governed by any special act. So there are many companies which are governed by special acts. What are those companies? Like say LIC. There is an LIC Act. Warehousing Corporation of India. Food Corporation of India. There are so many companies for which special acts are there. Now, in those acts also, there might be certain provisions relating to insolvency. So they are saying here, except insofar as the said provisions are inconsistent with the provisions of such special act. That means if there is a provision in LIC Act, which is a company which is governed by any special act. Suppose there are some winding up provisions in the LIC Act and there is some inconsistency, then the provisions in that special act will prevail. This is the meaning. I hope it is clear. Is it clear?
Yes, sir.
Haji. Then any limit, all of you are co-hosts, so you can mute if there is some disturbance. Any limited liability partnership incorporated under the Limited Liability Partnership Act. So companies, LLPs, companies governed by special acts. Then such other body incorporated under any law for the timing in force as the central government may by notification specify in this behalf. So here please note that they are referring to any such other body incorporated under any law. They are not referring to India or abroad. So this body which is incorporated under any law, it may be a Indian body, it may be a foreign body. Okay? So both are covered. Such other body incorporated under any law for the timing in force as the central government may by notification specify in this behalf. But to bring such body which is incorporated under any law for the timing in force, the central government has to issue a notification. Is it clear? Then personal guarantors to corporate debtors. A company has taken a loan. An individual who is a director of the company, he has given the guarantee. So the provisions of the code are equally applicable to personal guarantors also. Partnership firms and proprietorship firms and individuals other than persons referred to in clause E. So why they have made them separate? Personal guarantors have been kept separately and individuals other than persons referred to in clause E have been kept separately because some of the provisions have been notified for personal guarantors to corporate debtors. Otherwise, there was no need. They could have covered it into individuals alone. But in individuals also, they have made two bifurcations. One is personal guarantors to corporate debtors, for which rules and regulations are there, and for individuals, for which rules and regulations have not yet been notified. In relation to their insolvency, liquidation, voluntary liquidation, or bankruptcy, as the case may be. Okay? So, this is the applicability of the. Now, section 3. Section 3 says, in this code, so the word code is important here. I have highlighted in this code. That means the definitions which are given in section 3, they apply to the whole of the code. But the definitions which are say given in section 5, they are applicable to part 2 only. Similarly, there are certain definitions which are given in section 79, they are applicable to part 3 and so on. So in this code, that means the definitions which are given in section 3, they apply to the whole of the code. So in this code, unless the context otherwise requires, board means the Insolvency and Bankruptcy Board of India established under subsection 1 of section 188. So board is the IBPA. Like in income tax, board means the Central Board of Direct Taxes. Similarly, here board means the IBPA. Bench means a bench of the adjudicating authority. The adjudicating authority, we have already seen yesterday, adjudicating authority may be NCLT or DRT. For corporate persons, it is NCLT, National Company Law Tribunal, and for individuals and partnership firms or other non-corporate entities, it is the DRT. Bylaws. Bylaws means the bylaws made by the Insolvency Professional Agency under section 205. So bylaws is another concept. We have seen that there are rules. Rules are framed by the central government. For that, the central government issues a notification and rules are made by the central government through Ministry of Corporate Affairs. Regulations are made by the board because this law is because it is in its infancy. Still, this IBC is in its infancy. So they are saying that let this law evolve through rules and regulations. You might have noticed that there has been no amendment in IBC since August 2021. So it has been almost 4 years and there has been no amendment in the code. But they are amending the law through rules and regulations. Because the procedure for amending the act is more complicated than amending the regulations. So bylaws. Bylaws means the bylaws made by the Insolvency Professional Agency. Now, what is this Insolvency Professional Agency? Insolvency Professional Agency is something similar to a college. Suppose you are doing law, then you will get admission in a law college. So that law college is the Insolvency Professional Agency. And the university, a university shall be the IBPI. So IBPI is something similar to university. IPA is something similar to a college. So you are subjected to monitoring by college also. Similarly, Insolvency Professional Agency will also monitor your activities. You will be required to pay them fees. You will be required to comply with the notices which are issued by the Insolvency Professional Agency. And you will be required to file certain periodical forms also with the IPA. So IPA is something similar to an institute, you can say, or a college. So bylaws, they make the bylaws, but those bylaws, but the IBBI has made model bylaws. So these bylaws, which are made by the Insolvency Professional Agency, they have to be in consonance with the model bylaws. Can anybody tell me how many insolvency professional agencies are there as of now?
3, sir.
Yes, three. So there are three insolvency professional agencies promulgated by the three institutes, ICI, ICSI, and ICMAI. But if you are a chartered accountant, you need not necessarily register yourself with triple IP ICI. You can register yourself with triple IP SI also or CMAI. Similarly, advocates they can register themselves with anybody. They can change also. Like you can change from one college to another. You can take migration. But for migration, what you have to do? You have to take NOC from both. So similarly, here also, you can also migrate from one IPA to another in case you are not satisfied with the services. Now charge. Charge means an interest or lien created on the property or assets of any person or any of its undertakings or both, as the case may be, as security and includes a mortgage. So charge. So whenever you take any loan, so the person giving the loan expects that you put some property under his control, whether directly or indirectly. So this process of giving your property in the control of another is the concept of charge. So charge means an interest or lien created. So in whose favor that interest or lien is created? It is created in favor of the person from whom you have availed loan. So charge means an interest or lien created on the property or assets of any person or any of its undertakings. Now, what is the meaning of undertaking? The undertaking here means a set of businesses. Suppose you have got four plants, so you can create charge plant wise also. Similarly, if you have got different businesses, then the creation of charge or creation of lien could be business wise also, as the case may be, as security and includes a mortgage. So even mortgage is included in charge. Chairperson means the chairperson of the board. So chairperson means chairperson of the board. Board here means IBPI. Now claim. Before understanding the definition of claim, we have to keep in mind three things. One is claim, another is debt. So claim is different, debt is different. Now what is the claim? So claim means that you are entitled for a certain sum of money. So this much is sure that you have to get some money. So right to payment. You have got a right to payment. Suppose that you are executing a construction project. So in that construction project, although no measurement has yet been done, no billing has yet been done, but you have done something for that project. It is in progress. So you are entitled for a claim. So claim means right to payment. Whether or not such right is reduced to judgment, that means suppose some court case is going on. But if you have got a right to payment, then you are entitled for a claim. Reduced to judgment, fixed, disputed, undisputed. Suppose the client is a builder and you are a contractor and your case is under dispute. So the question here is whether you will be entitled to file a claim. The answer is yes. You may not be allowed to initiate the process being an operational creditor because in case of operational creditors, they allow you to initiate the process only when the amount is undisputed. But in case of disputed amount, they may not allow you to initiate the process, but you are allowed to file your claim. So initiating the process and filing the claim are two different things. Fixed, disputed, undisputed, legal, equitable, secured or unsecured. So whatever be the type of right to payment, it is covered under claim. So that means whenever a company is into insolvency, then you will be entitled to file a claim. Then right to remedy for breach of contract. Under any law for the timing in force, if such breach gives rise to a right to payment. Whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. Just a minute. Just.
Sir, you are mute.
Yes. So claim. Claim means right to payment, whether or not such right is reduced to judgment. So I told you a case of a claim where you are not entitled to initiate the process. But even if the case is under arbitration, what we have read in IBC, we have read in IBC that an operational creditor cannot initiate the process in case there is a dispute between the parties because it is not a recovery mechanism. But once the process is initiated, he is entitled to file the claim. So whether court proceedings are going on, whether surface action is taking place, whether some arbitration case is going on, still he will be able to file his claim. Disputed, undisputed, legal, equitable, secured or unsecured. Then second is right to remedy for breach of contract. Sometimes you have the right to remedy for breach of contract, provided if such breach gives rise to right to payment. That means, let us see it by way of an example. You are a contractor and the client is required to issue you free steel and cement. The client doesn't issue you free steel and cement, and you are not able to perform your part of the job. But it is written in the contract that in case free steel and cement is not supplied by the client, then you have got a right to remedy for breach of contract because you have deployed your labor, you have deployed your machinery on the job, and you are incurring losses because of the action of the other party. So in such a case, in such a situation, this situation will be covered by here. Right to remedy for breach of contract. Under any law for the time being in force, if such breach gives rise to right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. So both these situations will be covered here under the claim. Next is corporate person. Now corporate person means a company as defined in clause 20 of section 2 of the Companies Act, a limited liability partnership as defined in clause N of subsection 1 of section 2, or any other person incorporated with limited liability under any law for the timing in force, but shall not include any financial service provider. Now, they have defined the word corporate person. Actually, this entire this IBC is divided into various processes depending upon the type of person. If you are a corporate person, then you are governed by part 2. If you are a non-corporate person, individual or partnership firm, you are governed by part 3. But it specifically excludes any financial service provider within the definition of corporate person. Let us take the case of banks. If a banker has given a loan, then he can initiate the insolvency process against the company to whom they have given the loan. But let us reverse the situation. An individual has provided services to the bank. Bank is not paying. So in that case, whether you can initiate insolvency proceeding against the bank, the answer is no. It says shall not include any financial service provider. But whether banker can do anything and get away with it, the answer is no. The answer to this is given in section 227. Section 227 talks of a separate procedure for financial service providers because naturally they have to give some importance to financial service providers. Power of central government to notify financial service providers. Section 227, if we read, it talks of power of the central government to notify financial service providers. Now, what is this? This means that suppose a banker is into insolvency, banker is into some trouble, banker is not able to pay, then the government will get in touch with the regulator which is normally RBI. So they will get in touch with the RBI and they will issue a notification that such and such financial service provider needs to be brought into the ambit of IBC. So it will be by way of a separate notification. There is a separate procedure which is given in part 5. Okay? But he is not covered under the normal corporate persons. So if you want to bring an action against an NBFC, against a banker, like the case of Diwan Housing Finance was there. So it was covered by under section 227. Process is more or less similar, but an individual or a non-corporate entity, the government has to initiate the process. You can understand it like this, that in case of financial service provider, the initiation cannot be done by an individual or a corporate. The initiation has to be done at the behest of the central government by way of issuing a notification in consultation with the financial sector regulator. I hope this point is clear. Is it clear?
Yes, sir. In part 4, who all are covered, sir?
Part 4 basically talks of rules and regulations. In part 4, nobody is covered, but everybody is covered. Part 4 talks of the board, information utilities, insolvency professional entities. So it is procedural in nature. Information utilities. So what are their functions? How to get yourself registered with an IPA or IBPI? That is the procedure, it is mainly procedural in nature, part 4. So basically, part 2 and part 3. Part 2 corporate, part 3 non-corporate.
Thank you, sir.
And part 5 others like financial service providers. So it is miscellaneous. Yes. Corporate debtor. Corporate debtor is another concept. What they say? So corporate debtor means a corporate person who owes a debt to any person. Because if you have taken a loan, you may be a corporate person, you may be a non-corporate. So if you are in corporate form who has taken a loan, you will be deemed as corporate debtor. If you are an individual who has taken a loan, then you will be considered as debtor. Yes. Then core services. Core services means services rendered by an information utility for, as I told you yesterday, there is only one information utility, National E-Governance Services Limited. So core services means the services rendered by an information utility for accepting electronic submission of financial information in such form and manner as may be specified. So there are regulations, information utility regulations. Then safe and accurate recording of financial information, authenticating and verifying the financial information submitted by a person. Now, how this process takes place? Authenticating and verifying. Suppose a banker informs the National E-Governance Services Limited, NESL, which is the only information utility, that okay, such and such person has taken a loan. Now, they will shoot a mail to the other party, the person who has taken the loan, that okay, we have been informed by this bank that okay, you have availed loan from this bank, whether you confirm it. So the information is fed only when the other party confirms it. Now there could be 3 responses. Suppose an individual has got a mail from an information utility that okay, this bank has informed that you have taken the loan. First reaction, the person may say yes, I have taken the loan. So then it will be marked green. Second is he may completely refuse, I have not taken any loan, this information is wrong. Then it will be marked red. But third is he keeps mum, he keeps silent, he doesn't say anything. Then it will be marked as yellow. So yellow, green, and red. And providing access to information stored with the information utility to persons as may be specified. So they will provide access to information. I told you yesterday to register yourself, to try to register. Has anybody registered with the information utility? Any one of you? Even if you have not, try it today or try it in your spare time. It will not take much time and not much money. So please try to register yourself because you will learn a lot of things. Authenticating and verifying the financial information submitted by a person and providing access to information stored with the information utility to the persons who may be specified. Then creditor. Creditor means any person to whom a debt is owed. Like there is a definition of corporate debtor and debtor, but whether there is any there is any concept of corporate creditor or creditor? No, only creditor. In case of debtor, they have distributed into two parts: corporate debtor, and then financial service provider. But here only creditor. Creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured creditor, an unsecured creditor, and a decree holder. So creditor. Anybody who can explain the concept of decree holder?
A decree holder is a person in whose favor the court has given the decree.
Yes. So if you are entitled to some money from a person and you file a suit against that person and the court holds your right to receive the money, then he will issue an order which is issued by way of a decree that, okay, the assets of that person may be confiscated. So that is the concept of decree holder. So if you are holding a decree against anybody, then also you are treated as a creditor. And the person in whose favor, in against whom the decree is awarded, what is the term associated with such person?
Judgment debtor?
Yes, judgment debtor. Yes. Then debt. Debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. Now just see the difference. Claim, in case of claim, it was the right to payment. But here it is debt. So debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. So that means that amount should be due. If it is not due, then it is a claim. Let us again go back to the definition of claim. So what claim says? Claim says whether matured or unmatured. Because it says reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. But here it has to be due also. So a claim, every claim is not a debt, but every debt is a claim. Because they say debt means a liability or obligation in respect of a claim which is due. So a claim which is due is a debt. Okay? From any person and includes a financial debt and operational debt. Default. Default means the non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor as the case may be. So default means non-payment of debt when it is due. Okay? Then financial information. Financial information in relation to a person means one or more of the following categories of information: a record of the debt, a record of liabilities, a record of assets, record instances of default, record of balance sheet, such other information. Now, financial institution. Financial institutions means the scheduled bank, which is given in the schedule annexed to the RBI Act. Financial institution as defined in section 45I of the Reserve Bank of India Act. Public financial institution as defined in clause 72 of section 2 of Companies Act, and such other institution as the central government may by notification specify. So financial institutions, banks, financial institutions as per section 45I, public financial institution, section 2 subsection 72, and such other institution as the central government may by notification specify as financial institution. Financial product. So financial product means securities, contracts of insurance, deposit, credit arrangement. Say there is a ULIP plan. So ULIP plan is a product. CC facility, credit arrangements, including loans and advances by banks and financial institutions. So there is a term loan. So that term loan is a product. LIC policy, it is a product. Retirement benefit plans, there is some national pension scheme, NPS. It is all financial product. Financial service. Financial service includes any of the following services, namely accepting of deposits, safeguarding and administering assets, offering. So all these, say, companies which are dealing with insurance, which are dealing with shares. So they are all financial service providers, basically. If it's an insurance company or a company which is offering, say, mutual fund. So mutual funds, they are all financial service providers. Financial service provider means a person engaged in the business of providing financial services in terms of authorization issued or registration granted by a financial sector regulator. This is important. Everybody who is providing financial services is not a financial service provider. So who is covered? Who is authorized? Suppose you want to form an asset reconstruction company. So that asset reconstruction company has to be authorized in terms of registration granted by the RBI. But suppose you are a private financer, you are a private money lender. So then you are not a financial service provider. In that case, you are an operational creditor only. You are not a financial creditor. It has to be regulated in terms of authorization issued or registration granted by a financial sector regulator. Financial sector regulator. Financial sector regulator means an authority or body constituted under any law for the time being in force to regulate the services or transactions of financial sector and includes RBI, SEBI, IRDA, PFRA and such other regulatory authorities as may be notified. Insolvency professional. Insolvency professional means a person enrolled under section 206. So this word enrolled is important here. So you have to enroll yourself with an insolvency professional agency and you have to register yourself with IBPI. So you cannot say insolvency professional means a person registered under section. So you cannot get yourself registered with IPA. You have to enroll yourself. So enrolled under section 206. Like if you go to college, they will give you a roll number. So this is something similar. Enrolled under section 206 with an insolvency professional agency as its member and registered with the board as an insolvency professional under section 207. Then insolvency professional agency. Insolvency professional agency means any person registered with the board under section 201 as an insolvency professional agency. Like I told you, the concept of insolvency professional agency is something similar to the concept of college. So a college also, if you want to open a college, then you have to register yourself with the university. So similarly, this insolvency professional agency is also required to get itself registered with the board. So board is regulating both the insolvency professional agency and insolvency professionals. Information utility. Information utility means a person who is registered with the board as an information utility. So even information utility has to be registered with the board. So board is controlling whom? Board is controlling insolvency professionals. Board is controlling insolvency professional agencies. Board is controlling information utilities. Now insolvency professional agency. Insolvency professional agency is the link between the insolvency professionals and the board. Insolvency professional agency is also monitoring the activities of insolvency professionals and it is responsible to the board also. It is answerable to the board also.
Sir,
Yes.
insolvency professional entities?
Yes, insolvency professional, actually insolvency professional could be an individual or an entity. Like I told you, there has been no amendment in the code since August 2021. Earlier, the insolvency professional entities were only recognized. They were not being registered. But now they are registering them as well. As of
With
now,
IBPA?
yes. So with IPA also.
Uh-huh.
So here now, but there has been no amendment in the code. And in the code, there was a concept of insolvency professional only. And then by way of regulation, what they did, they said that insolvency professional means an individual or an insolvency professional entity. So indirectly, they covered the entities. In the code, only the word insolvency professional is there. But in regulation, they said that insolvency professional means an individual or an entity. So indirectly, they covered it. Earlier, they were only being recognized. They were not being registered insolvency professional entities. But now they are also being registered. Notification. Notification means a notification published in the official gazette, and the terms notified and notified shall be construed accordingly. So notification is for rules, for regulations, for everything. Person. Person includes. Sometimes in the definition you will find the word means, sometimes you will find the word includes. Like in notification, they are saying notification means, but in person they are saying includes. So it is an inclusive definition. And as per the rules of interpretation, whenever the word includes is used, it means more could be added. But if it is means, then it is a conclusive definition. So person includes an individual, HUF, company, trust, partnership, LLP, and any other entity established under a statute, and includes a person resident outside India. So even a person who is resident outside India is included in the definition of person. Okay. Whether a foreign company is covered, the answer is yes. It says any other entity established under a statute. So if a foreign company is also covered here in point number G. A person resident in India shall have the meaning as assigned to such term in clause 5 of section 2 of FEMA. And person resident outside India means a person other than a person resident in India. And here the definition of person resident in India as per FEMA is different from the definition which is given in the Income Tax Act. Because in Income Tax Act they say that if you have been a resident, if you have been a resident in a particular country for a period of 182 days or more, then you are a resident. But in FEMA, they are seeing at the intention also. Suppose a foreigner comes to India and he stays in India for a period of 200 days. But still, he will not become a resident of India. Why? Because his intention is not to stay in India. He has come to India on a pilgrimage, say, on a tourist visa. So, they say that the intention is also important. Similarly, if a person has left the country for permanent employment abroad, then also he is not considered as a resident. So, along with the residence number of days of stay in India or abroad, we have to see the intention also in FEMA. Let us go to this definition. Let us go to this FEMA Act. Just a minute. It will take just 1 minute. Let me take you to that definition also. So this is my website. Here you go to Knowledge Bank. You go to Acts and you go to other statutes. In other statutes, you will find FEMA, FEMA 99. So in FEMA, if you go to section 2, this is section 2. Section 2 definitions. Section 2, 5. B. B is no? Yes. V. Person resident in India. I hope my screen is visible.
Yes, sir.
So person resident in India means a person residing in India for more than 182 days during the course of the preceding financial year. Please note, the wording used is more than 182 days. That means even if the stay is 182 days, then also he will not be covered. More than 182. More than 182 means 183 or more. Okay? सुधीर जी आप पढ़िए एक बार जरा इसको,
A
पढ़ा जाना
person,
आपसे।
yeah, a person resident in India means a person residing in India for more than 182 days during the course of the preceding financial year, but does not include a a person who has gone out of India or who stays outside India in either case for or on taking up employment outside India, or for carrying on outside India a business or vacation outside India, or for any other purpose in such circumstances as would indicate his intention to stay outside India for an uncertain period.
Let us stop here. So here let me give you a situation. Ramlal has stayed in India for a period of 200 days. Okay. But now he has gone abroad and he is permanently settled abroad. So whether he will be considered a resident or not, as per FEMA.
No, sir, he will not.
Yes. So this is the crux. Now please read part B.
Part B says a person who has come to or for stay in India in either case otherwise than for or on taking up employment in India, or for carrying on in India a business or vacation in India, or for any other purposes in such circumstances as would indicate his intention to stay in India for an uncertain period.
Hmm.
Any person or body corporate registered or incorporated in India, an office, branch or agency in India owned or controlled by a person resident outside India, an office, branch or agency outside India owned or controlled by a person resident in India.
Yes, yes. So let us stop here. So he says person resident in India means a person who has come to or stays in India in either case. Otherwise than for or on taking employment in India, for carrying on in India a business or vocation in India. So basically, along with the number of days, which is more than 182 days, there are two things to remember. It is not 182 days, it is more than 182 days. And second is the intention is important. Even if you have stayed in India for 200 days, but you go permanently outside India, then you are not considered resident in that particular year. Yes. And person resident outside India means a person who is not resident in India. So now I hope this definition is clear. So basically, we have to see the intent also in case of FAME. Okay. Just a minute. So we were on this. So person resident in India. Person resident outside India means a person other than a person resident in India. Prescribed. Prescribed means prescribed by rules made by the central government. Property. Property includes money, goods, actionable claims, land, and every description of property situated in India or outside India, and every description of interest, including present or future or vested or contingent interest arising out of or incidental to property. So whether cash in hand is a property?
Yes, sir.
Yes, cash in hand is a property. Whether Bitcoin is a property?
Yes, sir.
Yes. So property includes money, goods, actionable claims, land, and every description of property situated in India or outside India. Whether shares is property?
Yes, sir.
Yes, everything is. Whether brand, the say brand value is a property. Suppose a brand has got a certain value, say 5 crores. So whether it will be covered under property or not?
It should be covered, sir.
Yes. Regulations mean the regulations made by the board under this code. So regulations are made by the board Rules are made by the central government. Bylaws are made by the insolvency professional agencies. Schedule means the schedule annexed to this code. Secured creditor. Secured creditor means a creditor in favor of whom security interest is created. And we discussed yesterday also that secured creditor could be both a financial creditor or an operational creditor. Even an operational creditor could be a secured creditor if he has been given some security for performances of his part. Security interest. Security interest means right, title, or interest or a claim to property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance, or any other agreement or arrangement securing payment or performance of any obligation of any person. So, this is the security interest. Provided that security interest shall not include a performance guarantee. Specified. Specified means specified by regulations. So wherever in the code you find the word specified, it means specified by the regulations. And the term specified shall be construed accordingly. Transaction includes an agreement or arrangement in writing for the transfer of assets or funds, goods or services from or to the corporate debtor. Although it says includes an agreement or arrangement in writing, but whether verbal agreements are covered, the answer is yes, because it is an inclusive definition only. The only idea of reducing the terms to writing is that in case of any dispute, it could be established if it is in writing. If it is verbal, then it could be difficult to establish. Suppose there is a supplier of goods. There is no written agreement, but he supplies the goods to the company. So whether he is transacting with the company, the answer is yes. Although there is no written agreement, but they are saying for transaction, they are saying includes an agreement or arrangement in writing for the transfer of assets or funds, goods or services from or to the corporate debtor. Then transfer. Transfer includes sale, purchase, exchange, mortgage, pledge, gift, loan, or any other form of transfer, right, title, possession, or lien. Then transfer of property. Transfer of property means transfer of any property and includes a transfer of any interest in the property and creation of any charge upon such property. Workman shall have the same definition as assigned to it in clause S of section 2 of Industrial Disputes Act. So workmen also, on workmen also, they sometimes ask this question. So let us see the definition as per Industrial Disputes Act and what is covered and what is not covered.
So, before that, regarding this definition of transfer,
Yes.
it's mentioned that the mortgage and pledge is also comes under the definition of transfer.
Mm-hmm.
But transfer mortgage is only where we are just giving that as a security or pledging. Means
Mm-hmm.
transfer will take place only once that the obligation or the debt due was not paid on time, then only the action on mortgage or the pledge will be taken. Then
Actually, the idea here is that we will read about it in detail in Transfer of Property Act. So transfer does not mean the absolute transfer. Transfer here means creation of an interest. So if you have taken a loan and you've created a charge, that person has got interest in the property. So to that extent, this is transfer. So transfer does not mean physical possession. That does not mean physical transfer. That means creation of an interest. So that means to that extent, he is also having some interest in that property. So that way we should understand it. But in detail, we'll read about it in Transfer of Property Act. So about this Industrial Disputes Act. So Industrial Disputes Act, I hope now it is visible on your screen. Section 2. This is section 2, section 2S. Workmen. I hope now it is visible on your screen. So workman. Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be express or implied, and for the purposes of any proceeding under this Act in relation to an industrial dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, or retrenchment has led to that dispute, but does not include any such person. So, who are not included? Air Force, Army, Navy Act. So the personnel of Air Force, Army or Navy, they are not covered under the definition of workmen because they are normally not entitled to resort to this Industrial Disputes Act. Who is employed in the police service or as an officer or other employee of a prison? So if you are an employee of a prison or you are employed with police, then also you are not covered under the definition of workman. Who is employed mainly in a managerial or administrative capacity, who being employed in a supervisory capacity draws wages exceeding 10,000 rupees per month. So these are not covered. So basically, who are not covered? Army, Navy,
Navy.
Air Force personnel,
Right.
police personnel, employees of prison,
Yes, sir.
then managers, etc. And if you are drawing salary wages exceeding 10,000 rupees per month. So they are not covered.
Sir, managerial or administrative capacity means IAS or something like that?
No, no, no. If you are just a manager, if you are accounts manager, then you are not a workman.
Okay, okay.
ये हो गया अच्छा
Sir, in this definition, if a person is employed in the capacity of a worker, but he's getting a salary of more than 10,000 rupees, will that be a workman?
then also will not be covered.
Then he will not be covered.
Please say na, who being employed in a supervisory capacity
Yeah,
draws wages exceeding 10,000 rupees.
अच्छा एंड हो गया ठीक है
दोनों चीजें हैं.
ठीक है सर
भाई कई बार क्या होता है, उसको मैनेजर नाम दे दिया और सैलरी उसकी है 5,000 रुपए, तो फिर कवर नहीं होगा. ओके. Now, words and expressions used but not defined in this code, but defined in the Indian, because some of the definitions they are not given in the IBC. Indian Contract Act, Indian Partnership Act, SCRA, SEBI, RDB, LLP, and Companies Act. So you refer to those definitions which are given in those acts. ठीक है, तो ये हमारा हो गया सेक्शन 3 तक कंप्लीट. नाउ सेक्शन 4. सेक्शन 4 क्या बोलता है? सेक्शन 4 बोलता है एप्लीकेशन ऑफ दिस पार्ट. सो दिस पार्ट, एनी क्वेश्चन ऑन सेक्शन 3? सेक्शन 3 तक कुछ क्वेश्चंस? ओके. तो व्हाट आई विल डू इज आई विल गिव यू एन एक्सरसाइज ऑल्सो. एमसीक्यू आप अटेम्प्ट कर लीजिएगा घर पर, है ना? सो आई विल पोस्ट इट इन द ग्रुप. नाउ लेट अस मूव टू सेक्शन 4. अभी सेक्शन 4 पर चलते हैं. So section 4 says application of this part. So because now we are in part 2. So it says application of this part. This part shall apply to matters relating to insolvency and liquidation of corporate debtors where the minimum amount of default is 1 lakh rupees. Because when this code came, the amount was 1 lakh rupees. Provided that the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 crore rupees, and the central government has issued a notification. So central government by way of this notification, so they have made it 1 crore. Provided further that the central government may specify such minimum default of higher value which shall not be more than 1 crore rupees for matters relating to pre-pack. So for pre-pack also, they have issued a notification that the minimum amount of default in case of pre-pack shall be 10 lakh rupees. So for pre-pack, minimum is 10 lakhs. For CIRP, it is 1 crore.
Very good.
But there is no maximum value. Only minimum value has been given. So, because pre-pack is restricted to certain types of corporate persons, corporate MSMEs. So, if there is an MSME and there is a default of 200 crore rupees, so that MSME can go in either for pre-pack or for normal CIR. Now, section 5. Section 5 says in this part, because in section 3, when we were reading section 3, so it was saying in this code. But now in section 5, they are saying in this part. That means the definitions which are given in section 5, they apply to part 2 only. So in this part, unless the context otherwise requires adjudicating authority for the purpose of this part, means the NCLT. So because we are reading for corporate persons, if we see section 4, part 2 when starts, it says insolvency resolution and liquidation for corporate persons. So part 2 deals with corporate persons only. And we have seen already that for corporate persons, the adjudicating authority is NCLT. Okay. Auditor means a chartered accountant certified to practice as such by the Institute of Chartered Accountants of India. Okay. So even if you are a chartered accountant, but you are not having certificate of practice, then you are not an auditor. Base resolution plan. This concept of base resolution plan is applicable in case of pre-pack, because in case of pre-pack, the corporate debtor itself is allowed to put forth a plan, a resolution plan, which is termed as base resolution plan. So base resolution plan means a resolution plan provided by the corporate debtor under clause C of subsection 4 of section 54A. Section 54A talks of pre-pack. Then chapter. Chapter means a chapter under this part. Constitutional document. Constitutional document in relation to a corporate person includes articles of association, memorandum of association of a company, and incorporation document of a limited liability partnership. So incorporation document of limited liability partnership is normally the LLP agreement. Okay. Corporate applicant. Corporate applicant means a corporate debtor. So there is a difference between corporate applicant and corporate debtor. Corporate debtor is different. Corporate applicant is different. So corporate applicant means a corporate debtor or a member or partner of the corporate debtor who is authorized. Basically, they are saying that who is entitled to make an application. They say that the corporate applicant shall move the application. Now the corporate applicant, they have included not only the company, but the CEO, CFO, a person who is in charge of managing the operations, who is controlling. So financial controller will be included under the definition of corporate applicant, CEO, CFO, everybody will be included. Okay. Corporate applicant. Corporate guarantor. Corporate guarantor means a corporate person who is the surety in a contract of guarantee to a corporate debtor. So there could be two types of guarantors. One could be an individual, the other could be a corporate guarantor. If a company has given a guarantee, then that company will be considered as corporate guarantor. If an individual has given a guarantee, then he will be considered as personal guarantor. If a partnership firm has given the guarantee, then they will be considered as guarantor. Okay. Dispute. dispute includes. So this definition of dispute is an inclusive definition. But when we read the Bankruptcy Law Reforms Committee report, BLRC, there they use the word dispute means. But when they made this into act, when they made this into code, they replaced the word means by includes. So dispute includes a suit or arbitration proceeding. So if we read this line, it means that there could be a situation where there is no suit, no suit has been filed, no arbitration proceeding is pending, but still there could be a dispute. Suppose a supplier of goods has supplied services, he has supplied goods, but the goods are not in conformity with the terms of agreement. The goods are not of specified quality. Inspection department has rejected the goods. Although no suit or arbitration proceeding has been filed, but still a dispute exists. And in that case, the person who has supplied the goods, he cannot initiate this process. But if the process is initiated by somebody else, then he is entitled to file the claim. So dispute includes a suit or arbitration proceedings relating to existence of the amount of debt. So first could be the amount of debt itself is disputed. One party is saying that I have given 1 crore rupees. The other party is saying that you have given only 75 lakhs. Second could be the quality of goods or services or breach of a representation or warranty. So dispute includes a suit or arbitration proceeding relating to the existence of the amount of debt, quality of goods or services, or the breach of a representation or warranty. Then financial creditor. Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred.
स्टेशन पर उपलब्ध है अधिक जानकारी के लिए कृपया 15537
चंद्रशेखर जी म्यूट कर लीजिए अपने को चंद्रशेखर जी प्लीज म्यूट योरसेल्फ you can unmute yourself if you want to speak something. Okay. So financial debt means a debt along with interest. So debt includes not only the principal amount but interest also, if any. This word if any I have highlighted because there could be an interest-free debt also. I'll ask you a question here. Suppose a holding company has given loan to its subsidiary company without payment of interest. So whether that holding company can initiate this insolvency process in case the subsidiary company doesn't pay?
Yes.
The answer is yes. So financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money and includes money borrowed against the payment of interest, any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent. So some of the concepts which are described here in section 5 subsection 8, they are applicable to foreign jurisdictions also. Sometimes what happens is, suppose you go to a foreign country and you raise the money. So sometimes what the companies do, they undertake that, okay, in case your investment is not subscribed, then we will accept this as a credit. So acceptance credit facility, some sort of, you can say, underwriting. Amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent. Any amount raised pursuant to any note purchase facility. If you have gone to USA, you have issued bonds there. So that note purchase facility is also there. Or the issue of bonds, notes, debentures, loan stock or any similar instrument. Some sort of underwriting, you can say. Amount of any liability in respect of any lease or hire purchase contract which is deemed as a finance or capital lease. So operating lease is not covered here, only finance or capital lease is covered. Receivables sold or discounted other than any receivables sold on non-recourse basis. So this is something called factoring. So what suppose you have got some bills which are outstanding, so you can get those bills discounted. So receivables sold or discounted other than any receivables sold on non-recourse basis. It could be, this is discounting of bills could be on recourse basis or it could be on non-recourse basis. Non-recourse basis means that even if the final party doesn't pay, then you cannot go back to the person to whom you have given the finance under this discounting facility. There are two parties, A and B. A has supplied the goods and B is the party who has received the goods. Now, A is the party who is entitled to some money from B. Now A goes to C. C is a factor. So he says, and C says, okay, I'll discount your bills. And even if B doesn't pay, then also I will not claim the money from you. So then it is on non-recourse basis. But if C says that, okay, I'm discounting your bills, which you are entitled to get from B for supply of goods, but in case B doesn't pay, then you have to pay. So it is on recourse basis. This is the difference between recourse and non-recourse basis. So which type of receivables sold or discounted are covered other than sold on non-recourse basis? Okay. That means sold on recourse basis are covered. Any amount raised under any other transaction, including any forward sale or purchase agreement having the commercial effect of a borrowing. And any amount raised from an allottee under a real estate project shall be deemed to be an amount having the commercial effect of a borrowing. So, home buyers are covered here. And the expression allottee and real estate project shall have the meaning respectively assigned to them in RERA Act. So, this allottee and real estate project, we have to have reference to the RERA Act. Any derivative transaction, any counter indemnity obligation, amount of any liability in respect of the guarantee or indemnity. So these are the various types of financial debts. Financial position. Financial position in relation to any person means the financial information of a person as on a certain date. Information memorandum. Information memorandum is something similar to a prospectus. It is the document which is to be used by the resolution applicant to know about the company. Because books may say something else, but this information memorandum is based on the factual position. It is based on the claims received. It is based on the various assets and liabilities, including contingent liabilities, which the company is having. So information memorandum means a memorandum prepared by a resolution applicant, resolution professional under subsection 1 of section 29. Initiation date. Initiation date means the date on which a financial creditor, corporate applicant or operational creditor, as the case may be, makes an application. So the date when you make the application, that is different, and the date when the application is admitted is different. So date of admission is the insolvency commencement date. Date of filing the application is initiation.
Okay.
So initiation date means the date when application complete in all respects is filed. Suppose you go to the registrar office and you submit the application, but the registrar refuses to accept. They say that, okay, affidavit is not attached. So in that case, that date will not be the initiation date. The initiation date will be when they give you a reference number. So whenever you file an application, they will give you an acknowledgement and a reference number. So that is the date which is the initiation date. Application complete in all respects. Insolvency commencement date. Date of admission of an application. Insolvency resolution process cost. This is a very important concept. Insolvency resolution process cost. It means the amount of any interim finance and the costs incurred in raising such finance. Because this company is into insolvency. Now they are short of funds. So that means they need some finance. So that finance is the interim finance. And somebody who has given finance to you in your difficult circumstances, naturally, he needs some preference. So that is why this insolvency professional process, this insolvency resolution process cost is the cost which has to be paid in priority to the debts before any debt is paid, whether secured or unsecured, first of all, this insolvency resolution process cost will be paid. So the person who has provided interim finance in times of difficulty, that means he needs priority. So priority is according to the provider of such interim finance and the cost raised in raising such finance. So cost incurred in raising such finance, whether it be by way of bank charges or interest or processing fees, whatever is included in the term cost, that will also be paid. Fees payable to any person acting as RP. So RP is some sort of a Pandit. So Pandit has to be paid in priority. So if you have asked a Pandit to come to your place for performing a ceremony, birth ceremony, marriage ceremony, death, anything, so he will be paid, whether or not you are having money. So he has to be paid in priority. Even if you are not having money, you will borrow it from your relatives. So this money has to be paid to the RP. Any cost incurred by the RP in running the business of the corporate debtor as a going concern. So this is also important because this company, this corporate debtor has to be kept as a going concern. And suppose there are some suppliers who are providing you goods or who are providing you services, then they also need priority. So any cost incurred by the resolution professional in running the business of the corporate debtor as a going concern, it also has to be paid in priority. Any cost incurred at the expense of the government, because not too many persons will be willing to supply goods to a company which is into insolvency. Suppose it is a turbine unit. Now for running the turbine, you may need coal as a fuel. Now the coal supplier will not supply you coal unless he is assured of the payment. So they say that you will be given priority. So any cost incurred by the RP in running the business of the corporate debtor as a going concern, so that will be included in insolvency resolution process. Unless he is assured of money, why he'll give supplies to that company which is already into insolvency? So that is why they are given precedence. Any cost incurred at the expense of the government to facilitate the insolvency resolution process. Suppose the government incurs some expenses. The government allows the company to avail certain facilities. So that cost also will be paid in priority. Any other cost as may be specified by the board. So all these are to be paid in priority before any payment is made to any secured or unsecured creditor. Insolvency resolution process period. So means the period of 180 days beginning from the insolvency commencement date and ending on 180th day. So the planning has to be done that all the activities are completed by the end of 180th day. So you will not plan your activities in such a way that you shall be allowed extension. Although there is a provision for extension of time period of 90 days, but you will plan your affairs in such a manner that all the activities are completed by 180th day. And you have to satisfactorily account for each day of delay to the adjudicating authority. And time, once it begins to run, it will end only on 180th day. No holidays, nothing. Interim finance. Interim finance means any financial debt raised by the resolution professional during the insolvency resolution process period or by the corporate debtor during the prepackaged insolvency resolution process period, as the case may be, and such other debts as may be notified. So it says interim finance means any financial debt raised by the RP during the insolvency resolution process period or by the corporate debtor, because in this prepack process, the corporate debtor stays in control. So if the corporate debtor stays in control, he will raise the interim finance. So this interim finance is the financial debt raised by the RP during this period or by the corporate debtor. Okay. Why this is important? Because this interim finance is included in the insolvency resolution process. So both the principal amount and the interest and the cost associated, everything is covered. If we see section 5 subsection 13, it says the amount of any interim finance. So that means the principal is also covered and the cost incurred in raising such finance is also covered. Okay.
Sir, so insolvency resolution process will also cover the liquidation stage, or it's only for the...
No. As of now, there is no liquidation. So once the insolvency fails, once the insolvency resolution fails, only then liquidation will take place.
Okay, so resolution means to start up the company again. So that's how it
Yes,
works.
to keep
Okay.
it as a going concern and to sell it off to somebody else.
Okay. So that is required to be done in 180 days.
Yes, 180 days. One time extension of 90 days and maximum 330 days, including any period lost in litigation.
Okay.
Then liquidation cost. Liquidation cost means any cost incurred by the liquidator during the period of liquidation, subject to such regulations as may be specified by the board. So liquidation cost means any cost incurred by the liquidator. Then liquidation commencement date means the date on which proceedings for liquidation commence in accordance with section 33 or section 59 as the case may be. Because in section 59 covers voluntary liquidation cases. So in case of voluntary liquidation, there is no interference by the adjudicating authority. So basically, in case of a debt-free company, you can voluntarily liquidate your company by just passing a declaration and by passing a special resolution. Liquidator means an insolvency professional appointed as liquidator in accordance with the provisions of chapter 3. Officer. So this definition of officer is also important. Officer, for the purpose of chapter 6 and chapter 7 of this part, means an officer who is in default in clause 60 of section 2 of Companies Act or a designated partner, because sometimes there are some penalty provisions also. So there are penalty provisions on the officers in default. So who are mainly responsible? Either an officer in default or a designated partner in case of an LLP. So wherever they have used the word that, okay, officer shall be liable or penalty shall be levied on the officer, or he may be subjected to imprisonment. So wherever the word officer is used, so officer means an officer who is in default as per Companies Act or a designated partner in case of LLP. Then operational creditor. Operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Okay? Then operational debt. Operational debt means a claim in respect of the provision of goods or services, including employment, or a debt in respect of payment of dues arising under any law for the time being in force and payable to the central government, any state government, or any local authority. Okay? Goods or services, employment, debt in respect of payment of dues arising under any law for the time being in force and payable to the central government, state government, or any local authority. So these are all included under operational debt. So I'll ask you a question here. Suppose I have subscribed to the shares of a company. I applied for shares, but the company did not allot me any shares. And now the company is into CIRP. So whether I'll be a financial creditor or operational creditor.
No one, sir.
So what is my status?
I am just a creditor, sir.
Yes. So I'll be covered under other creditor. So I'll have to file form F. Because there are separate forms for financial creditors, for operational creditors, and for other creditors who can claim the money. So I'll be covered under other creditor. Personal guarantor. Personal guarantor means an individual who is the surety in a contract of guarantee to a corporate debtor. We have already seen the definition of corporate guarantor. So corporate guarantor means a corporate person who has given a guarantee. Here, an individual who is the surety. Personnel. Personnel includes the directors, managers, KMP, designated partners, and employees if any of the corporate debtor. Then preliminary information memorandum. This concept of preliminary information memorandum is applicable in respect of this pre-pack process, because the control lies with the corporate debtor. So corporate debtor itself will prepare this preliminary information memorandum, and based on the information which is given in the preliminary information memorandum, the resolution professional will prepare the information memorandum in pre-pack process. Wherever section 54 is being referred to, so 54 here means the pre-pack. Then pre-pack insolvency commencement date, when the date of admission of the application under pre-pack. Then pre-pack insolvency resolution process cost, something similar to insolvency resolution process cost. Then prepackaged insolvency commencement period. So period beginning from the commencement date and ending on the date on which an order, actually in case of prepack, it may result in resolution, it may result in liquidation. There are various processes in which it may end. So that is whatever way it is ending. So they say insolvency resolution process period. Basically it is 120 days. Then related party. Related party will do tomorrow, because related party itself is a very wide concept, very large concept. So tomorrow onwards we will take this related party, but I'll share the illustrations on a related party, which you should go through on your own before you attend the class tomorrow morning. Thank you very much. If you have any questions, you can ask. Yes, Supriya ji. I hope I'm clear.
Yes, sir. Understood. I'll go through it, sir.
You are understanding whatever
Yes, sir.
I'm telling? Okay, okay. Thank you.
Thank you, sir.
Or Sabir Rafael ji, how are you?
Yeah, fine, sir.
हाँ जी.
I shall go through the notes now.
हाँ. So
And
you
then
should
I have
get in
it.
touch with that Bina also, है ना?
Yeah, sure,
Both of you
definitely,
can
definitely.
study. हाँ,
Yeah,
हाँ.
sure, sure.
Okay, okay. Okay, you have a good day.